Well, welcome to the Aging Boomers. I'm your host, Frank Sampson. And of course, on our show, we discuss so many of the issues facing boomers, their parents, and what we know, of course, is an aging population. And we have another wonderful guest with us today. But before I introduce her, I want to remind everybody that today's show is sponsored by Senior Care Authority, a professional senior placement and elder care consulting organization that has a national network of advisors to help in determining the right path for senior living and receiving proper care. So whether it's in-home care, assisted living, residential, or memory care, get the necessary advice from a senior care advisor in your area by calling Senior Care Authority at 888-809-1231, or you can go directly to the website at www.seniorcareauthority.com. And I want to give a little plug for myself here. I did come out with a book recently called The Aging Boomers. Thank you for all your support. It's out on Kindle on Amazon. Just type in The Aging Boomers, and the actually paperback is coming out. Should be on there within the next week, so you can get the paperback as well. And thanks for all your support there on that. And I'm very excited about our guest today. Not only will she be providing all of us with some great information, but she's a local here in Northern California. Bridget Mackay has been practicing law for over 20 years. After graduating from Santa Clara Law in Santa Clara, is it Santa Clara University, or is it just Santa Clara Law, Bridget?
Santa Clara University.
Yeah. All right. She spent 10 years as a deputy district attorney in both Solano and Sonoma counties. After the birth of her daughter, her priorities changed a little, and she started her own practice in estate planning and Medi-Cal, sometimes known by most of you as Medicaid benefits planning. This transition was a natural fit, and all of her skills of listening, compassion, and fearless pursuit on behalf of her clients translated well to this area of law. She is a member of the American Association of Estate Planning Attorneys, National Association of Elder Law Attorneys, and California Association for Nursing Home Reform. So, Bridget, I just want to thank you so much for joining us on the Aging Boomers.
Thank you.
Yeah, great to have you. So you've written a white paper, okay? And I hope I'm not messing up the name, but it's 10 things to be aware of before placement in a nursing home. And I found that white paper, which will tell people how to get to it, but we're going to go through some of the points. Hopefully we'll get to all of them. And talk about that, because I think each point needs certainly some explanation. It will be beneficial to our listeners. So how about if we do that? Sound good to you?
Sounds great to me. Thank
all right, great. So I know, one of the things that we talk about quite often on the show, and we just can't talk about it enough, all right, is for people to plan, all right? And I know that the first point that you bring up, is making sure you have a power of attorney, living trust, healthcare directives. And why do you think people put that off, and tell us really what's involved on putting that type of information together before going into nursing or any type of long-term care for that matter?
I think what I've found with clients, the number one reason has been just simple procrastination. I think people really want to do it, but they don't want to address the issues. Sometimes families have a problem child, or they feel like there's an issue that they just don't want to have to look at, and they know they will have to do that when they go into planning. The other common thing I see with, and the reason I made that number one with elders going into skilled nursing, is the elder may have done some sort of planning, a trust, a will, power of attorney, but it's hadn't been looked at in a long time, and that sort of was the trend, or is the trend in my profession. Estate planners, and I think for people, they get their will done or their trust done and the power of attorney, and they sort of check that off the list, put it in the drawer, and walk away and feel that they're covered, and never really look at it again until it's needed. The unfortunate thing is when it's needed, whatever they have in there may not be up to date. So, that point's really about two things. Number one, definitely you can't tell people enough to plan. But number two, keep your plan updated. Keep a look at it. Remind yourself who you've named as your trustee and who you've named as your healthcare agent, because you're not going to know when you're going to need it.
So if someone doesn't have a trust, okay, and what are the risks they're taking?
Well, the risk, from my perspective, the biggest risk they're taking is their estate, the management of their health, the management of their finances should they become incapacitated, stroke, Alzheimer's, a form of dementia, Parkinson's, any of those diseases of aging would be in court. They would have to go to court to get someone to determine, and sometimes this means even their spouse. I think people are under the impression that the spouse is automatically their representative and their health care decider, which in practicality in front of a doctor or a nurse or in an ER, they will listen to a spouse. But as soon as you start needing to place someone in care, long-term care, the administration at that long-term care facility is going to want some paperwork that you have the authority to do that. And if you don't have that paperwork, you're going to court to get it, and it's 5-10 times more expensive than just doing the planning to begin with.
What do you say to people? What do you say to people? And I just heard this just the other day. All right. Hopefully I gave them the right explanation. But they say, power, I say you got to have a power, you got to get the power of attorney done. And they go, well, you know what, I could just go online. I'll just go online and download it and fill it out and get a, witness or a notary or whatever the case. What do you say to people who want to kind of take maybe the less expensive way out? What risks are they taking by even doing that?
Well, I think they're risking for the little that they're going to save and not consulting an attorney who can kind of look at everything they have and make sure their plan. A lot of those online documents don't deal with all of the tools you're going to need to prepare your estate for a long-term care stay in a skilled nursing facility. And so that one document can cost, I've seen, anywhere between $200,000 to $300,000 at the end of the day, because that family is in court to get the things they need that those online documents don't provide to care for their elder.
Yeah, I even had a client, end up being referred to me after the fact here, but they did one of those, they just went online, and then the adult child, who was a power of attorney, went to the bank to either draw out funds or at least control the account, which was the proper thing to do, because their mother, father, whoever it was, they weren't capable of really managing that anymore. But the bank wouldn't do it because the power of attorney form wasn't done in the proper way. So, it caused a lot more hassle. Yeah,
it does. I'm sort of talking about numbers, cost and numbers, but you can't imagine the amount of stress, hassle, time that these kids are spending on sort of making things happen for their parents when they haven't sort of set it up smoothly.
Right.
And I don't know what the emotional cost is.
Right. And also, you don't want to wait too long. Am I right? Sometimes they wait. Well, my father's got dementia, and I better get a power of attorney. what advice do you have there?
Right. That's a very good point. You don't want to wait too long, because then it becomes too late and your elders lost capacity. And so they don't have the mental capacity to make choices or informed decisions about these types of things that's legally required for them to have. So that's one mistake I see a lot in my practice. And I don't know if this is a sort of parent, adult, child, elder parent dynamic. I suspect that it is, where they're hesitant to step in, and they're hesitant to start taking over things for their parent. They want them, I think in your heart of hearts, you want them to be independent. You don't want to treat them like a child. And oftentimes elders present in the moments that they see them with enough capacity, but you spend more than 2 hours with them and you really see how downhill it's gotten. That's too late. It's
Right.
really a conversation you need to have when your parents are healthy, and just say, is everything in order? If it is, who's named? Can we get some of the documents? And I think people are afraid to ask that because there's a fear that they're seen as greedy, or they want to know how much money they have. And I have definitely seen elders react that way, but I often tell my clients, no, you want the next generation to be prepared for this. You don't want it to be a big surprise for them, or for it to be too late for you.
Yeah. So, Bridget, I'm going to get on to your second point. I mean, at this pace, we'll probably it'll take us a few hours, so, but we'll move along. But the second point you bring up is a nursing home being the highest level of care. And talk to us about that, because I know, as you know, that's the field I'm in, and there's a lot of choices out there for people. A lot of people kind of say nursing home when maybe they don't even mean nursing home. But why don't you talk about that a little bit?
Yeah, I'm sure you see that in your practice too, because I think people. I think nursing home is probably used as the code word for, my parent needs help and can't live at home anymore, and that's the first thing they think about. But you're right, there are a lot more choices prior to that, and it's all really based on what level of need and what the resources are of the senior. I mean, I think ultimately you want your senior to be at home and in their familiar environment for as long as possible. And so, that first level would be in-home care. Some people shy away from that, and some elders shy away. They don't want someone strange in their house. The children don't want to risk valuables. A lot of different dynamics come at play there. But there's also that very comfortable level of board and care, or assisted living or independent living, where the senior is getting sort of their basics taken care of, meals, even maybe some medication help. And I've found that level of care, before you even get to skilled nursing, is sometimes very nice for particularly isolated seniors. So they've aged in place, but it's become very isolating for them at home. And so that brings another dynamic, and I've often had clients say if their parents are placed in a board and care or even assisted living, their social network has grown and they seem a little more active in their life. There's that mental stimulation is there, and so they're feeling better, they're being more active, and they're improving.
Yeah. It's interesting. It's interesting you bring that up, because really, in California, and this is pretty common throughout the country, but nursing homes are considered a medical model, while assisted living, even memory care, are considered a social model. All right.
Yeah,
and,
that makes sense.
But that social model. More and more, the regulations are changing to allow assisted living, memory care to do more for their, for their residents, and then, nursing homes is really for, like you have stated, a higher level of care, but it's important, for people to look at that and do they really need to be in nursing. But regardless, all the things we're talking about applies. Your power of attorney and living trust, it kind of doesn't matter whether it's nursing or assisted living. Is that right?
Right. I know for sure if you are in an assisted living environment in memory care, they require a power of attorney before they will place an elder in there.
Right. Exactly.
They need someone who's on who has capacity to consent on their behalf.
Yeah. The other misconception, I'd love to hear more about it, is this feeling that, my mom has Medicare, so that should cover everything, right?
Right. Yeah, that is the big myth. And I think people think that their regular health care premiums have some influence on whether or not long-term care is going to be covered. And more particularly, that myth is more common in nursing home because, to a degree, Medicare does pay for some nursing home, but it will not pay for anything short of that, assisted living, board and care. It'll pay to a certain extent some in-home treatments, but those are all based on recovery out of a hospital stay. So, moving on to nursing home care, and that, the reason Medicaid or Medi-Cal in California gets brought up at this stage is because it's, nursing home care is the most expensive you're going to find for care, unless you're doing 24-hour in-home care.
Right.
Then hopefully that senior has the resources to cover it and everything's fine. But oftentimes the situations I'm looking at are families whose parents, one parent, and there's maybe one well parent at home, are looking at needing skilled nursing, and that's, they're unable to do 3 or more activities, sometimes 2 or more activities of daily living, dress themselves, toilet themselves, feed themselves. They're not mobile, or they have those problems and memory care issues. Then really the best location for them are skilled nursing facilities. Mm-hmm. And Medicare pays for a small portion of it. If you are in, say your parent fell, broke a hip, was in the hospital to replace that or repair that, and then went to a skilled nursing facility for rehabilitation, Medicare will pay for a guaranteed 20 days of that stay. It will pay up to 100 days, but that 80-day gap is based on an evaluation they make periodically of that person that they are actually rehabilitating. As soon as the evaluation by the caregivers and the doctor say they're no longer rehabilitating and you're still within that 100 days, it can cut off. And they'll give you only 3 days notice.
Right.
And they'll say, we're not paying for it anymore.
Yeah.
And then it's up to the patient to pay. It's a private pay situation, and that's when I see clients. They turn to us and they say, is there a way for us to get Medi-Cal?
Yeah. So let's talk about that. So let's say that, Medicare is not going to pay anymore. If the family says, well, mom really needs to stay here, and then they realize the cost of that, which could be pretty significant, what steps did they take? You mentioned Medi-Cal. For those of you listening and you're not familiar with Medi-Cal, that's just the term used in California for Medicaid, which is the term in most states. Right. But I'm sure the laws vary a little bit state by state, but generally speaking, I think that the things that you'll go over right now probably apply to most around the country. But let's talk about that. So someone, what's involved then to get approved on Medi-Cal or Medicaid from that point, using that example you just gave?
So there is actually a big divergence in regulatory application. between California and the rest of the United States.
Okay.
Which,
all right.
it comes as no surprise as Californians.
Yeah. Highly regulated state.
Well, actually, the rules here are a lot looser than they are in the rest of the United States.
Oh, really?
They're regulations that control them come from the federal government, and the states implement them with some federal and state funding combined. And the rules that California operates under right now were 1990 rules, the MSERA law. And the rest of the state is under the DRA Act of 2005, the Deficit Reduction Act. California's the legislature's adopted those rules. They're now at the Department of Health Services for implementation and have kind of languished there for the last, 2016, so probably the last 10 years.
Mm-hmm.
So what I'm about to say, I'll outline general requirements to qualify for Medi-Cal / Medicaid. But as we get into, we're over that general requirement, can we move assets around in order to become eligible? That will differ greatly from the other 49 states.
Got it.
The other 49 states having harsher rules and it being less, not as easy to qualify.
Gotcha.
So
okay.
The basic rule is it's an asset-based test of whether you qualify. So income doesn't really come into play until later, but essentially if one spouse is going into skilled nursing and there's a well spouse at home, you can have roughly $120,000 in assets, but no more in order to qualify. Now, they don't count the value of your home. They consider that exempt because they just don't. They don't count one car, and if you have an IRA, and this actually rule is distinguished by the rest only in California. If you have an IRA and it is paying out the required minimum distribution, then that asset is not counted. So it really looks at what's in your savings, what's in your checking, do you have a brokerage, do you have more than one car, more than one property. All of those things will be added up, and if it's over $120,000, then you're not eligible for Medi-Cal. If you're a single person, that number drops significantly. You can only have $2,000 in assets to qualify. Same exemptions apply as they do the couple. So, it really is intended for impoverished seniors to help them. And if you qualify, that means that Medi-Cal will pay a majority of that monthly cost. Right now in Sonoma County, the monthly average is $8,500 a month in a skilled nursing facility, and I think the state average is around that as well. I have seen places that have, if you're in memory care in skilled nursing, can go up to $12,000 a month. So it's a huge savings for that senior who qualifies. And there is a formulation once you qualify how much you pay and how much Medi-Cal pays. It's called the share of cost, and that is based on income. Essentially, everything but $35 in income would go to the facility. So typically it's the senior Social Security, maybe small pensions. Subtract $35 because they figure that's enough money for you to buy personal things a month, and that's what you would be paying. If you're a married couple, the well spouse at home gets to keep of that income. They get to keep $3,000, all of their income, and if that's not enough to meet the regulation $3,000, they get to keep $3,000 a month. If their individual income is not enough to reach the $3,000, then they can get this ill spouse's income to reach that amount. But anything over that of the ill spouse's income goes to the facility to supplement the Medi-Cal payment a month.
There's a lot to know.
Did I lose everybody?
There's a lot to know. We only have a few minutes, unfortunately, but what I'd like you to talk about, because I hear this all the time, is, mom's got, probably too much money. We better move some of her dollars out of her account into our account so it will show that she doesn't have as much money. Maybe we move some of her assets over. Tell us about that.
That's a critical one, and I hear it too. And I know we don't have much time, so the takeaway from whatever I'm going to say next is don't do that unless you have consulted an attorney who's experienced in Medi-Cal or Medicaid benefits planning, and that's what it would be called on their advertisement or whatever, because you can really, really mess someone up. The short answer is yes. We can qualify people by moving assets in all 50 states. California's rules are much more liberal, but they're still very treacherous rules. That if you, often people assume, well, I'll just gift, my mom will gift the federal estate tax exemption amount, which is $14,000, until we're down to, the required $2,000. And what they're doing is potentially disqualifying them from Medi-Cal, because if the gifts or the movement of money is too large and outside of the regulatory accepted amount, then they get disqualified, per month in relation to how much they moved erroneously. So you can disqualify them for up to 2.5 years if you don't do it correctly.
Yeah. So consulting an
really
attorney
a scary
is
thing
is
that you don't want to do it yourself.
Yeah. So consulting an attorney is extremely important. And speaking of that, so if somebody did want to, talk to you or learn more about your firm and what you do, tell us about that. And then second part to that question is if people are not in California, do you have any recommendations for them of how they could find a specialist like yourself in their particular state? Yes.
So we do this type of planning in my practice. We're at BridgetMackayLaw.com, BRIDGET. is the Bridget, and Mackay, Mackay.
Law.com. So Bridget Mackay Law.com. I pronounced your name wrong, so I apologize. Bridget Mackay.
Oh, that's okay. That's all right. It doesn't faze me anymore. I answer to Mackay all the time. And the process is, can be done quickly. We prefer if there is some prior warning, so mom or dad are in a skilled nursing or it's looking like they're going in a skilled nursing, that's preferable. Then, oh my gosh, Medicare just cut off, we need Medi-Cal now. Because it does take a little bit of timing, especially if you're moving some funds, depending on how much funds you need to move, you need to build in some time. But if you are not in Sonoma County, you're elsewhere, there is the California Association of Nursing Home Reform, or called CANNER. They have a website, and I think if you just type in California Association of Nursing Home.org, they have a list of referral attorneys. We're on it, and a bunch of other attorneys who have specializations in this area. In the rest of the country, I would point to two resources. NALA, National Association of Elder Law Attorneys, have attorneys that practice in Medicaid benefits planning, and also the American Academy of Estate Planning Attorneys, which I belong to, have members that also do this kind of work in all the other 49 states. So do a little research. Make sure you go to an estate planning attorney who knows about it. And I think most of us in this area, we would be willing to. I get many referrals from other estate planning attorneys who don't do it. They know they don't want to tread into those waters because it can be very treacherous regulatory-wise.
It's definitely a specialty. It's a specialty.
Yeah, and if it goes wrong, it can go horribly wrong.
Right. So I know we didn't get through all the points that you wrote in your white paper. So again, why don't you just tell people how, if they want to read the white paper, it's on your website. So tell them again how to get to your website.
Yeah, just go to my website, www.bridgetmackaylaw.com. The white paper is there. I do some educational video blogs on this subject. Those are also there.
Great.
Yeah, there should be a lot of resources there.
Perfect. Bridget, thank you so much for joining us. Wealth of information, and appreciate you taking the time. Really do. And I want to thank everybody else out there for joining us. Thanks for all your support. Keep get the word out to your friends and family. Of course, as many of you know, you could go on to iTunes, iHeartRadio, download the app on your iPhone, Android phone, iPad, etc., the Aging Boomers app, all different ways to keep up. So just be safe out there, and we'll talk to you all soon.